thought of something we call, in the Peter Munya case, that elections are normative derivatives of the Constitution. What does that mean? Is different from standard. Who has the burden to prove, and what is the threshold of the proof? And we settle this in a lot of cases. But in the last 4 election petitions, we have somehow managed to settle it. So, for example, we deliver the short judgment on the 14th day, and then 21. All the court will no longer be able to work during the election period because all the disputes will come to court. But IEBC has a duty. And we also determine the appellate mechanism of the different electoral seats. And we have said FCAs can start at the magistrate court, and then they come to the High Court, and then the dispute mechanism. You remember the case, some of you may know, a very controversial case around. The case came all the way to the Supreme Court, and we had, by a majority of 4, with Chief Justice Maraga and myself, these were the sentences. What I know about myself, I call myself a pragmatic liberal. These judges who make judgments and they ask the question, what is the impact of my judgment on the people? So I'm not one of those guys who, sorry, I have to say guys because you're guys. I'm not one of those judges who writes a judgment and then says, this is the black and white letter of the law. So if you read my judgment in Sato Zayuma, I hope you've read it. In Sato Zayuma, I said, we cannot just have evictions without certain conditions before evictions are conducted. And then I said, I'm going to follow up as a judge. And so I introduced what we now call the structural interdicts to ensure that my judgment is followed and effected. That's how a pragmatic liberal judge was, and that is me. The 4 election petitions that we've now handled gave us an interesting name in 2017, if you remember, the first one. The 2013 judgment was an interesting judgment because Chief Justice Mutunga came and in 2 minutes said, we dismiss the petition. And then the judges walked out and there was a crisis. So you've dismissed it, and now I'm speaking bad English, because of why? The reasoning was that the court was young, the court was 1 year old, it had never handled a case of such magnitude. And so in 2017, when I joined in 2016, we probably gave a better account of ourselves. Because in the first petition, when we nullified President Uhuru Kenyatta's election, we gave a short judgment that explained why we dismissed, why we nullified the election. In 2022, while we didn't allow the petition, again we gave better reasons than before. But I must say a little bit about 2017 because when the Supreme Court, 4 of us of the 6 that sat, determined that the presidential election was not conducted according to the edicts of the Constitution, we were called names. Do you recall President Kenyatta saying, how are you Kora? He also said, how can 4 people determine to overturn the will of the people? And in a democracy like ours, and you must appreciate I'm discussing all these things in the context of democracy. Article 140, Sub-Article 3 specifically says, it is the role of the Supreme Court to determine whether a presidential election was conducted within the law. And in 2017, the first petition, we said, no, it was not. Because we could not track the votes that were announced to belong to President Uhuru Kenyatta. So we were doing our democratic duty. We were not assuming the role of the people of Kenya. We were actually confirming that their will was not attended to when the figures that were announced in Bomas, we could not trace them backwards through a process called verifiability. And Article 10, Article 86, Article 88, Article 89 of the Constitution say every election must be transparent, must be accountable, and the results must be verifiable. So when one lawyer said in the petition, it doesn't matter how the figures announced belong, we said no. 1 + 1 cannot be 3. So you cannot say because the results are 3, it doesn't matter whether you got it 3 + 0 or 1 + 2. We must interrogate because the process is as important as the result. And that is how any democratic election must be conducted. So my colleague Justice Ibrahim says this about that election. And he unfortunately fell ill during the 2017 election, so he didn't sit until the end. But he says this in a paper I presented the other day. Our pride is not being the first or fourth country to annul the court, to annul the election. But the fact that the court was able to follow the constitution and reach a decision by a majority that is constitutionally sound. I think that's a good point. That the court was not acting out of whim. It was not being flippant. It was not being whimsical. The court was following the constitution in saying this election cannot be verified and therefore we must annul it. But every time I go to speak, sometimes I get this interesting question. Judge, so what do you do between the presidential election of 2022 and the one of 2027? What would you do? Because we only hear of you, except me sometimes when I make a few noises on social media and then you guys say, oh, that guy says hashtag this, hashtag that. What do you guys do? So let's try and understand what the Supreme Court does. The Supreme Court does not just do presidential elections. And I know that you know the jurisdiction of the court. Apart from presidential elections, we also hear appeals, including appeals in election matters. Just last year, we nullified the election of the Member of Parliament for Magarini constituency because we thought his election was not conducted according to law. Presently, we have a case where a candidate in the election for Speaker of the County Assembly of Migori has challenged the process of election of the Speaker in 2022. And so that many of those cases we do. But the court also, over time, has settled some of the issues that were teething and were new under the Constitution. Number one, I hope you've been taught of something we called in the Peter Munya case, that elections are normative derivatives of the Constitution. What does that high-sounding manenos mean? It means that even if elections are conducted under the Elections Act, the elections must meet the principles of the Constitution because, you know, simply in constitutional law, every statute must meet the master and expectation of the Constitution. So that even if you come to challenge an election under the Elections Act, if somebody introduces a constitutional element to the election, the Supreme Court can assume jurisdiction as a matter of right under Article 163, Sub-Article 4A. Number two, we grappled with the question of the burden and standard of proof in elections. You know that in the law of evidence, burden is different from standard. Who has the burden to prove and what is the threshold of the proof? And we settled this in a lot of cases. Number three, we settled the question of timelines under the Constitution. You know that the Supreme Court in the presidential election petition the petition must be filed, heard, and determined within 14 days. We think that period is short, but in the last 4 election petitions, we have somehow managed to settle it. So, for example, we deliver the short judgment on the 14th day, and then 21 days later, we deliver a long judgment. And so if you look at the Uhuru Kenyatta petition, all the Raila Odinga petitions, 2013, 2017, 2022, we have addressed this question. We have also addressed the role of IEBC and the role of the courts in determining disputes. And we have said IEBC should settle some of the smaller disputes before they come to court. Otherwise, all the courts will no longer be able to work during the election period because all the disputes will come to court. But IEBC has a duty under the Constitution to resolve some of the smaller disputes. And that is why now they have an IEBC dispute resolution committee that settles petty issues that don't have to come to court. We have also settled the question of conduct of repeat elections. In 2017, the August election was repeated in October, and we gave the parameters for doing so. We also determined the appellate mechanism of the different electoral seats, and we have said MCAs can start at the magistrate court, and then they come to the High Court, and then they come to the Court of Appeal, and then they stop. When the Supreme Court now starts handling disputes I used to go to the Runyanja's court here. So imagine if the MCA for Runyanja's has a dispute, and then they come through the entire court system to the Supreme Court to tell us what if the Court of Appeal has settled the matter. So we are saying we also don't want that because of the legal process, it begins from Runyanja's to Embu, to the Court of Appeal in Nyeri, to the Supreme Court in Nairobi, and the Supreme Court delivers a judgment a few months before the next election. Because that's what used to happen before. Now we have said, let it stop at the Court of Appeal. We have also resolved the issue of pre-election disputes and exertion of available dispute mechanisms. You remember the case, some of you may know, a very controversial case around whether the governor of Wajir County had a degree or not. And the case came all the way to the Supreme Court, and we had, by a majority of 4, with Chief Justice Maraga and myself dissenting, the court determined that the man was qualified, although Chief Justice Maraga and I thought he was not. So we are saying again, let us settle the question of education. Are you qualified? Are you not qualified? We have also settled the place of scrutiny of votes. You know, in Kenyan elections, every time, like in the Embu poll, when results are being tallied, there's always a dispute. And so when you come to court on a petition, we have settled the procedure, the process, and the content of the scrutiny of votes. We have also determined what is the role of the chairperson of the IEBC vis-a-vis IEBC, core IEBC. So we settled whether the late Wafula Chebukati could do some things as chairman, or he could do some things as the commission. And again, that's an important point, which we shall discuss if we get time. We have also settled election offenses. Because election offenses, some actually bring around questions of a quasi-criminal nature. Many years ago, a gentleman called Musikari Kombo was found guilty of election offense because he had submitted, I hope there are Bukusus here, he had submitted some Bukusu voters to an oath called Huria Siluru. And so the court found that when you submit people to an oath, which is akin to witchcraft, and they vote based on the fear of the effect of the oath, that's an election offense. So he was banned from running for office for 5 years. He's still my friend, but I always laugh about the Huria Siluru oath. This must now take me then to the subject which I was asked to speak about. Where is Christy? Christy, I'm going to speak about that section 3, which you want to speak about, because section 3 then brings all these things I've said to why the Supreme Court is an important player and actor in entrenching democracy in Kenya. Section 3 of the Act, Supreme Court Act, says as follows. It sets out the objectives of the court as 1, to assert the supremacy of the Constitution and the sovereignty of the people. I think I've spoken a lot about those 2 values. Number 2, to provide authoritative and impartial interpretation of the Constitution. Being the final apex court, it is this court that must be authoritative and final in doing this. Develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio-economic political growth. Kenya is a country with a history, both colonial and post-colonial, and pre- and post-2010, and it's important that we look at all those things in developing our new jurisprudence. Number 4, enable important constitutional and other legal matters to be determined having regard to our circumstances. And number 5, improve access to justice, and also provide for administration of the court through our registrar, and thank you, registrar, for the work you do, and all matters around our administration. And then that takes me to the question that I must ask now. How has this court fared since 2012? Put aside what my brother and friend Gran Mula says on social media. Put aside what my friend and lately not so good a friend Nelson Harvey says on social media. What has this court done in entrenching democracy in Kenya? I've spoken about the fact that the court in presidential elections has come out strong in settling all the issues that I've spoken about. One of the lessons that we must learn, however, is for the court to continue to settle impartially these issues, we must continue asking the question, what is a vote? What is a valid vote? And you remember the debate in the 2022 presidential election. At one point, we received affidavits saying that there was an attempt to say, bring the spoiled votes and add them to one candidate so that both candidates come to under 50 and then we have a runoff. We determined in the 2017 and 2022 elections what is a valid vote, what is a spoiled vote, what is a cast vote. That, for me, is a strong pointer to the democracy we are trying to build. We have also determined questions on the right to information. In 2013, I was still at the High Court. The Honorable Right Honorable Raila Odinga filed an application before me at the High Court seeking orders that he should get material, all the material held by IEBC, in order for him to file his petition. And I gave the order at 5 a.m. in the morning because the country was almost on fire. People were not sure what was going to happen. And so I had to sit, the Chief Justice asked me to sit at night because counting was still going on in Bomas. So I constituted my entire court, my legal researcher, my secretary, my court clerk. We were in court at 5. I gave the orders for them to photocopy all the material that they have. Today the law has changed. In fact, as soon as an election is conducted and the results are announced, all the material is brought to the Supreme Court. And then parties can access it on application, and we can access the material because it will be in our custody. So this right to information is a big hallmark of democracy. The other issue that we must continue addressing in a democracy such as ours is the issue of technology. Previously, election petitions in Kenya were settled around the following question. I spoke about witchcraft. If you are from Ukambani or Tharaka-Nithi, or you are from, you know that during elections, a lot of witchcraft comes into play. And I have no problem with those who believe in it. So a lot of petitions were being determined on account of witchcraft. And that is why the late Professor Onesmus Mutungi wrote his PhD thesis, professor, on the question of witchcraft and the Witchcraft Act. But then, do you know, have you read the Witchcraft Act? Please look for it. It exists. The second issue was violence, that our elections were being conducted in a very violent environment. And therefore, petitions were being brought to court on the question of violence. The third issue was corruption. People were giving voters 100 shillings at the entrance of the polling station before you go to vote. Today, believe you me, the biggest question we are dealing with is a question of technology. So that in the 2017 election, we dealt with technology as a big pointer to whether the election was conducted properly, because it's a pyramid. You have the polling station here, you have the National Tallying Center here, and you have the Constituent Tallying Center here. And the results must meet at the National Tallying Center for them to be valid. So technology is no longer a peripheral issue in elections. It is, and I can profess that in 2027, the biggest contest will be about how the elections were transmitted, whether we vote manually or we vote electronically, whether we identified manually or electronically. It will be a big issue in elections. And the court has written judgments around this question. The other issue which we have settled is the issue of case management. Case management is simply the period within which cases must be heard and filed and heard. And so in the case of Martha Karua versus Waiguru, the issue was whether all the courts had dealt with the matter within time. And when we in the Supreme Court refused to hear the merits of Honorable Karua's petition on account of time, she took us to the East African Court. The East African Court said that we did not give her the right to a fair trial, so they gave her 2 million shillings in damages. I don't agree with that decision. I sat as a judge of the East African Court for 7 years. I was deputy principal judge of that court for 4 years. I don't think that court has jurisdiction to determine such matters. But again, we must respect every judgment of every court, even if you don't like it. Even me, even if I respect it, nonetheless. And the question of time is important because in Zambia, for example, in the 2016 presidential election, the present president of Zambia, Hakainde Hichilema, filed a petition against the election of Edgar Lungu as president. But he filed it out of the time that had been given by the law. And so his petition was struck out only because he filed it some hours after the time that had come. And you know, in our case, almost always, the petitions are filed a few minutes before midnight of the 14th day. Imagine now if one day in this country, in a very contested election, suddenly one party is unable to file by the end of the 14th day, and they file a few minutes after the 14th day, and the court does not hear that petition. What happens to this country? So that the question of time is not a flippant point. It's not pedestrian at all. It is so fundamentally important because the right to access court, but within time, is an imperative we must accept. By the way, in Zambia, Edgar Lungu was punished by the voters in 2020, in the following election, by voting him out overwhelmingly to the extent that he could not file an election petition. And so, Hakainde Hichilema is the new president. Perhaps if that election petition had been had, and all the issues he addressed had been determined, Lungu may not have become the president of Zambia. So for us also, as Kenya, this question of time is so fundamentally important that even as we look at technology and how we file now in the courts all our matters virtually, we must be careful not to create a crisis created by technology and time, because this is quite possible in Kenya. I also must speak about the question of gender representation. You are aware that we say in our country that under Article 81, the electoral principle shall comply with the electoral system shall comply with the principle that not more than 2/3 of the members of the elected bodies shall be of the same gender. You know very well that today in Kenya, while at the National Assembly, women are only 23% of the vote, of the members. Rwanda has 60%. Uganda has 34%. What have our women lacked? Why is it so difficult for the nation to be like Embu University School of Law, where you have 258 women or men and 247 women? Is that not so? You are 50-50. Why can't the country have 50-50 like this faculty of law? What have women lacked that they should be 23% in the National Assembly? And so when we tried in the Supreme Court to settle the procedure of progressive realization of the right to gender parity, neither Parliament nor those that have the power to do so have acted. You recall also that Chief Justice Maraga, before he left office, directed the President to dissolve Parliament for failure to achieve the 2/3 gender rule. Again, we came in between that order, and the High Court gave a stay order, which I'm told the matter is being had by a 5-judge or 3-judge bench in coming days. But my point is this. The 2/3 gender rule is beyond legal dictate. We cannot argue about it anymore. We shouldn't argue about it. But it's about time that our people did focus on that one. I will jump the normative derivative principle, but just to say, like I said earlier, it is a principle that we must continue to look at because you cannot divorce statute from the Constitution. I spoke about tallying and collation of votes. I spoke a bit about complementary systems of results transmission. But let me speak to the BBI judgment as one judgment that probably, controversial as it was, in my view, entrenched our interpretation of the democracy that we have. You'll remember that the BBI case started in the High Court, and the reason really was President Kenyatta and Right Honorable Raila Odinga entered into what was then called the handshake. And one of the results of the handshake was what they called the Building Bridges Initiative. And I hope you've read that judgment. I know it's 1,000 pages because we each wrote a separate judgment. But what I tell people, don't read the judgment like a novel. So don't start from page 1 to page 1029. What to do, say, for example, you like me, assume you like me. Then you say, because I had him, let me go and read this BBI judgment. So you pick my judgment alone. Then one day you see Chief Justice comment. Then you say, she looks nice, she's from over here, Meru. That way you can understand how we reason out the matter. But if you read it as a long narrative, it will completely confuse you. So pick one judgment at a time, or pick one issue at a time. And the reason why this judgment is important is because Articles 256, 257, and 258 of the Constitution speak to what are basic clauses of our Constitution. Article 255, and in my judgment I said, you cannot, if you cannot amend these articles, unless you go through a referendum, then that is the architecture of, it's like the pillars of our Constitution, and you can never break those pillars, because if you break the pillars, the country collapses. Independence of the judiciary, that's a pillar you cannot ever break. If you break independence of the judiciary, and do what happened in the Moi regime, where my security of tenure was stripped in the afternoon, we cannot have a democracy. So the BBI judgment speaks to all these questions around boundary review, around creation of new offices under the Constitution. It speaks about one man, one shilling, one vote. It speaks about amendment of the Constitution and what are entrenched clauses. I challenge you to read that document. The other issue I must speak about in the context of a democracy is democracy and devolution. And again, I won't speak too much to this, but if you read the judgment of the Supreme Court in the Institute for Social Accountability and another was National Assembly, what we call the CDF case. I wrote that judgment at the High Court, and so I didn't sit at the Supreme Court. The point we're making is you cannot create a devolved government system like we have, then you still have members of National Assembly who are the ones who allocate funds to devolved units. Then they also come to their constituencies and counties, then they nyakua the same funds they have allocated, then they start using to build hospitals and toilets and roads. Because our democracy is structured so that the National Assembly cannot purport to become the devolved government unit. And the devolved unit cannot purport to do what the national government does. And that's why the Constitution speaks of Kenya shall be made up of the national government and devolved units. And so in that judgment, we clarify that question. Please also look at the case of Senate versus County Council of Governors. Look at the case of in the matter of the Speaker of the Senate. In all these cases, we have looked at the powers of devolved governments vis-a-vis the national government. Let me turn to one other element of a democracy that we must always continuously speak about. And it's in the context of the people, public participation. In this country, we created public participation as one of the values under Article 10. But over time, I must submit that we, the judges, have created more confusion than we ought to have. So if you look at the judgments, Robert Gakuru versus County Government of Kiambu, my judgment in Metropolitan Sacco versus County Council of Nairobi, you will see that Judge Odunga of the Court of Appeal and myself created different parameters for what amounts public participation. Gladly, in the case of British American Tobacco Kenya PLC, BAT Kenya, judgment of the Supreme Court, we settled the principles of public participation. And we said, in part, that the lack of a prescribed legal framework for public participation, we don't have a law for public participation. Kimani Ichung'wah crafted a law in 2022, 2021, it has never passed. So the fact that there is no law does not mean that the public entity cannot perform public participation. We also say it must be real and not illusory. You know, in this country there is this habit where people can call you by, like now they have called you to this lecture, then I say a few nice things, I tell you guys to sign, then I give you an allowance, then you say public participation has taken place. That is illusory, that is not real. Public participation includes the questions you're going to ask me, which is very rare that students can ask a Supreme Court judge some questions, so prepare yourselves. You must ask me questions. That is public participation. It must also be purposeful and meaningful. And that is why in the Finance Act 2023 case delivered in November last year, we said it must be purposive, it must be meaningful. So that even Parliament, as it looks for views from Kenyans, must tell us what it has done with the views. Suppose I come here, I ask you questions and tell me, okay, Judge, want to do the following, then I go and do completely the opposite of what you've told me. Was that now public participation, or it was merely that thing like puckering powder? It's like a facade makeup, which you can remove at some point. The notice must be reasonable. If you come to take views from the public and you advertise, the way I saw today on my way here, there are those posters for the agricultural show, which says it's going to be on these dates and that Nanjiru Stadium or whatever it was. But if you come the day before and say the show is tomorrow, bring your cows, you're not ready. So notice must be given. And then we also said, you can present your views in whichever manner. You can have written submissions, you can have oral submissions, but the fact is that you must be heard and given adequate time. So please look at the 2023 Finance Act case of the Supreme Court. Another hallmark of democracy is media freedom. I know that a lot of you of your generation, Gen Z, may not have seen a newspaper in a very long time, because in our age, Nation, Standard, they're all three laid out for you to read. Today you get news real time on your mobile phone, even as you are here. So although we have freedom of expression, and mainstream media is generally doing a good job, I think we need to start thinking about social media. Social media, in my view, has gone awry. It's gone absolutely crazy. And so we may need to look at Article 34. Again, freedom of the media does not mean that you can defame, you can insult. When, for example, you write and say, all the judges of the Supreme Court are corrupt. You don't mention what they have done, whose money they took, where. I thought as lawyers we were also taught that you must bring evidence of what you say. But social media, we have these guys who are called keyboard warriors. When you meet the person, like this gentleman here, he can't speak anything, but separate for 5 minutes, and then they go to that. The next thing they pour out there is total sewage. And because sometimes you don't know them, you can't even follow to sue them. And I'll give you an example. In the 2022 presidential election petition, a young man who I discovered later got a piece of the Star newspaper, and then he amended it and then said Lenaola receives 1.2 billion shillings from Gladys Jolie. So I went to my lawyer also is a keyboard warrior called Don Kipkori, and I told Don, follow this character. But this guy had used a pseudonym. His name was Karen Wanjiku, head of state commendation. So we went looking for Karen Wanjiku. We found a Karen Wanjiku at Multimedia University. When we caught the girl, she had no clue about this story. We got another Karen Wanjiku. Again, she had no clue. Then finally, the young man is arrested by some guy who speak about now. And then he goes to he was taken to Mudaga police station. And then finally he says, he put a picture of himself with that DCI board, the one where you hold a board saying, you're charged with this offense, cybercrime. And he says, this is so-and-so, alias Karen Wanjiku, head of state commendation. So, when he was taken to court, I looked for him. Then I asked him, do you know how much damage you have done to my reputation? I'm a judge recognized internationally for integrity. And now you, one guy, who was arrested in a small house in a place called Mudega in Kikuyu, a one-room Mabati house. And how he was struck was the DCI told him, we want you to become our influencer. So give us your number, then we shall send this 200,000 to you. He gave them the number, he was struck and arrested. So he's not even smart. My point is, social media, we have freedom of the media in Article 34. But when it's abused to the level that people like us in public office suffer injustice, suffer harm, suffer damage of our reputations, then that freedom ought to be curtailed, because Article 34 is not one of those rights that cannot be limited. I want to speak about two things before I close. I've spoken for too long. Integrity as a pillar in democracy. And earlier I said that Chapter 6 was put in place for a purpose. And today, the Supreme Court in the Sonko versus County Assembly of Nairobi case addressed the question of impeachment of public officers. In that judgment, we set out the role of the National Assembly, the role of the Senate, and the role of the court in determining whether a governor had been impeached properly. I encourage you to read that judgment. The last point I must make about our democracy, the second last point, is around constitutional commission. Kenya is very lucky in a sense that we no longer have the traditional three arms of government. It is now said that constitutional commissions are the fourth arm of government because, as you've noticed, the ombudsman, for example, is overseeing what the JSC is doing. And they're having that fight. Should the JSC report its work to the Ombudsman Commission on the Administration of Justice? So please look at the case of, read the matter of the Interim Independent Electoral Commission and look at the matter of the National Land Commission versus Attorney General. Our judgments in those two matters will tell you how we have dealt with these matters. Let me conclude by saying this. Again, in Kenya, we are very lucky that we are not struggling like other African countries. Between 2003 and 2022, we've had 18 unconstitutional governments in Africa. 18. If you add Gabon and Mali, there are 20. Those are countries where democracy has been put aside and military rule has taken place. We are therefore lucky in Kenya that we have institutions of the Constitution that are holding our democracy together. And one of those institutions I submit to you is the Supreme Court of Kenya. And therefore, forget what people are saying about the Supreme Court without evidence. Think, you found, those of you who saw the compendium, you will see that the court has settled very many questions of law and democracy in our country. And therefore, I submit to you that if you read Article 163 of the Constitution, which gives us mandate, and Section 3 of the Supreme Court Act, we have kept largely to our jurisdiction and to our mandate of sustaining our democracy through fair, impartial interpretation and application of the Constitution. I thank you very much.
Lecture, we can only give him a very
Judge, the Dean, DVC again, PAF, the Registrar, Supreme Court, students. Now, my years was in practice are too little, but I have been in class again. Nimesoma. And if the COD is saying the same, I'm sure very many of the questions you had are answered, isn't it? But I'm sure you have much more. Judge will say, I'm discussing which questions we can ask. And that one on the 14 days, and we were like, that one, why? Why is no point? You have answered. But we thank you very much, Judge, for that. But this session is for... So I first take 5 questions, okay? 5. And then once those ones, I have 3 from this side, 2 from this side, then we'll change. We have Ali, we have Kimani there.
Reconcile this. If the court is denying litigants their chosen representation, and we have the whole concept of unfettered access to justice, how does the court then reconcile these two things and offer a solution that can be tenable to both parties? Thank you.
It is a necessity or an inherence because currently we are having political influence from church and politics. How can we, as a major judge, can distinguish between us the church and how can the relationship between churches and politics, because it is a major issue currently, and we have seen youths currently saying occupy churches. Yeah, that's my question.
Good afternoon. My name is Brittany Nyamwange. I'm a third-year law student. I have a question on judicial independence. We know that judicial independence is the cornerstone of democracy, and it ensures that the rule of law takes precedence or prevails over political interest. So my question to you this afternoon is, how does the judiciary protect its judicial independence and legitimacy, especially when dealing with politically charged cases, putting in consideration the political climate of our nation today, and the fact that the judiciary faces a lot of political pressure, and what institutional mechanisms exist to protect the legitimacy of the court and to protect judicial independence?
Lord Justice Isaac Lenaola. My name is Kelvin Shundu. I have one question in relation to Article 168, Sub-Article 8, the Constitution, together with Article 50, Sub-Article 2, Paragraph Q. Your Eminent Grace, it is in public domain that you, together with your colleagues at the Apex Court, you are facing a possible X. And without asking you to comment on the substantive merit of the case, and with the burdens of caution the sub judice rule, I'd like to ask, what is the operation of Article 168, Sub-Article 8, because it provides that when the tribunal affirms the decision of the JSC, the aggrieved judges will have a remedy of appealing to the Supreme Court. I'm asking that question because the Supreme Court is facing the possible acts in entirety, and the remedy is for the Supreme Court to sit on the appeal. So which court will sit on that appeal? Thank you.
So,
Ali. So, I think Shirley has just spoken about Article 168 of the Constitution. That is the article that speaks to how judges are removed from office. And the grounds for removal include misconduct, incompetence, and so on. So that if a judge is removed from office, for example, let's give the example of my classmate and friend, Said Chitembu, who was removed the other day for misconduct. Ordinarily, in circumstances such as ours, he should not practice law again. Because then how can you be removed as a judge, but you're able to go and sit again to give advice as an advocate? So maybe that is a clear case. In 2003, we had something called the radical surgery, or what I call myself, the surgery by radicals, where a number of judges, and I sat in the tribunal investigating 5 of those judges. The reason why those judges were allowed to practice law is because although they left the judiciary in a cloud post the Ringera report, in fact they resigned. So if you have resigned and you have not been found culpable like Chitembwe or Mutavambalu, then it is very difficult to say to such a judge, you cannot practice. So separate a group that went through the entire process up to the Supreme Court, like Chitembwe. Or look at the third example, Lady Justice Mary Gitumbi. She's removed, and the Supreme Court sustained her removal on account of mental illness. Now, if you stop her from practicing, are you not punishing her twice? Because she's not been removed because of incompetence or impropriety or misconduct. And she's on medication. So why would you stop such a person from earning a living if during medication they can actually do what any lawyer can do? And who said that some of the lawyers walking around are themselves mentally well? So not everybody in a suit and appearing in court is necessarily non-compos mentis. So I think we must separate all the 3 categories of judges. Access to justice, the Amenasir case. I think you must understand that these matters are in court. They are in the High Court, they are in the Court of Appeal, they are in the JSC, they are in the East African Court. So again, thank you, Kimani, for raising it, and I'll come to, and I think it was Ali, it was Chundu who says, let's be careful with the sub-judice rule. But let me give you the story. You must appreciate that the case before the court filed by the judges is different from the case filed by Amenasir or his associates. Their case is that they were barred from appearing before the court. The court is saying, and the judges are saying, what happened was this. We wrote to him on the 18th of January to say, a matter is coming on the 23rd. And in that matter, we shall not allow you to address it. On the 23rd, every judge recused himself. So the judges are using the word recusal, not bar. And that is a question before the court. So the courts will determine whether the recusal order we issued on 23rd amounted to a bar. Number two, the court will determine whether if an advocate commits contempt in the face of the court or outside the court, what are the options available to the court? Is recusal one of the options? Is contempt punishment, a jail term, a fine, another option? And by recusing itself, did the court behave well? And also try to shoot this question. Those are the issues in court. I will not speak to them for obvious reasons. But all I can say is about Article 48. One of the pillars of the social transformation agenda in the judiciary is access to justice. So we are alive completely to the fact that Article 48 is alive and well. We are also alive to the fact that we are the apex court. We are alive to the fact that you have no other remedy if the apex court does not hear you. We are alive to that. But again, back to professional ethics. Isn't there a responsibility on parties appearing before the court to behave with decorum? Is there no responsibility in the courses that you are taught here and at School of Law in professional ethics that we are a profession of etiquette, a profession of decorum, a profession of good manners, and that if you as an advocate behave badly, the court has a right to take action against you? Is that not what we were taught? So when an advocate then does things that amount to complete denigration of the reputation of individual judges and the court itself, and remember, if the Supreme Court loses legitimacy, how can the judiciary maintain legitimacy? The Chief Justice sits there. The Deputy Chief Justice sits there. The 5 top judges in the country sit there. If they lose legitimacy, what is the legitimacy left for the judiciary? And therefore, it's a responsibility on both sides, both on the part of litigants and counsel, and on the part of the court, to ensure that between us, that respectability of the profession is maintained. And so those cases will determine all these matters one way or the other, but I hold very strong views myself about integrity of both sides, good conduct, and etiquette. Brian, I don't know why you asked me a question about the church and politics. I'm neither a politician nor a churchman. But to help you out of your conundrum, the history of the church and politics is as old as the church itself. Who was Jesus Christ fighting? Politician. Who was Herod? So who was Pontius Pilate? So the fight between the church and politics is as old as the creator of the church. If you read the history of the Roman Catholic Church, you'll find that at some point they had a love-hate relationship between the Pope and politicians. And at some point, popes were also politicians. They mixed. So it is nothing new. In this country, we have a season when there is a love-hate relationship between politicians and the church. For me, what matters is that the church performs its functions properly. The church is supposed to win souls for Christ, not lead souls astray from Christ. Let me now preach. So that I find difficulty in this new culture of the church, which is the prosperity gospel. Where when you go to church, and I stopped going a while back, when you go to church, all they speak about is how to make money. Churches are not hedge funds. They are not banks. They are not investment funds. So this nonsense where you go to church and half the preaching is about toa ndugu toa dada, and by these days what they do, I'm Anglican. And these days I notice that in fact the offertory is taken quickly before people run away from church. So even before, so normally you are preached for, then when the spirit is in you, then you give the offertory. But these days offertory is the spirit. So that is one. Let churches do what they are meant to do. Politicians also have a role to play, and they must play their role within the Constitution. But if the unholy alliance is created between these two, the country cannot move forward. For example, if politicians fight, is it not the church that's supposed to come and bring peace? Today they can't, because they are sleeping with one or the other. And so if you bring the church to mediate between two warring politicians, the one will say, lakini si wewe ni wa huko, na yeye tu na wewe pia si ni wa huko. So the church must remain away from politics. The church must stay away, so it becomes the salt of the earth. And those are my personal views. It's got nothing to do with the Supreme Court, of course. Nyamonge, judicial independence. Judicial independence is said to be in two instances. There is decisional independence, which is individual to me. How do I write my judgments? What influences my judgments? And then there is institutional independence. How independent is the judiciary, as a judiciary, from the influence of other arms of government? Judicial independence is very, very difficult to police, because judgeship is a very lonely job. When writing a judgment, say when I was at the High Court and I was a single judge, I can't even ask my wife, itaendaje kwa hii case? You can't ask your son even if he's a lawyer. Or even if your wife is a lawyer, you can't ask her. It's a very lonely job. So how you make your judgments as me speaks to your level of integrity. Integrity of the mind and integrity of your own conduct. So that if you want to be influenced, by the way, there's something called, I've been reading a lot, and I want to write a paper on bias that is unconscious bias. Sometimes it is possible that you're actually biased, but you may not know it. So if you're a Samburu like me, and my cows are stolen by Pokots, who are my neighbors, and one day you're sitting in a case involving a Pokot, do you know it's very easy for your mind to tell you this one, because a Pokot, who is easy to? So although you have not said so in the judgment, your reasoning follows something innate in you that makes you biased, and that is wrong. So we must fight both obvious bias and unconscious bias. Otherwise, then your decisions are not independent. So each judge, each magistrate must always struggle with that independence that is personal to you. Otherwise, your decisions cannot be legitimate if they're influenced by corruption, by friendship. One of the things that happens to a lot of us judges is you lose a lot of friends. Because when they come to you and tell them, sorry, I can't help you, they say, Sasa ameanza kuringa, you can't even help you. But you're trying to be independent of all these influences, including your closest friends. For the institution must remain independent. Suppose the Chief Justice, in the days of the other regime, Chief Justice Mutunga said when he entered the office of Chief Justice in 2012, he found a red telephone, one of those old ones. Then he asked the secretary, what is this one for? He says, this is direct line to State House. So he says, so how am I supposed to do? He says, when that one rings, it is the president calling. So that those days actually, the president would call and tell the Chief Justice, I want that case to go the following way. That is now, so the Chief Justice goes and tells the judge. That is how bad it was. I don't think we have that crisis today. I doubt our president would call and do that. And I doubt the Chief Justice would call a judge and say, that case you have, let it go this way. I doubt so, because nobody has called me. I would have said so, no, I don't hide this thing. So the beauty therefore is, we are able to create a highly independent judiciary with, of course, exceptions. People fail. People do make mistakes. But generally, we are trying to fight it internally. Shundu, therefore, an interesting question you've asked, which is also in the case that we filed in the High Court. If you look at my petition, I raised specifically the question you've asked. I said, number one, and I won't talk about the merits of the case, I'm just saying my case. I said, Article 168 does not envisage a situation where you are asking the JSC to commence removal proceedings of the entire bench of the Supreme Court, or even a collectivity of judges. Article 168 speaks to one judge, a judge, and misconduct cannot be collective. as far as I'm concerned. Misconduct must be individual. When you take your oath of office, you don't take together. You take it as yourself, and you sign the oath as yourself. When you breach the oath, I signed the code of conduct as myself. I didn't sign with Judge Oko or with the Chief Justice. So we are saying, if you want to remove judges of the Supreme Court, begin by proving your claim against each judge. But if perchance all the judges are removed at the same time, suppose these petitions go through and we are all removed, the law says that judge has a right to appeal to the Supreme Court. Now, in my petition, I said, look at the absurdity of Supreme Court judges appealing to themselves, saying our removal was unconstitutional. That is the absurdity we are saying. It must be resolved. And now, there is also a question which you may have to speak to the Dean about, the doctrine of necessity. In my petition also, I'm raising the question whether the Chief Justice can appoint a bench of more than one judge in this case, although she's affected by the complaint. She has a constitutional mandate to appoint benches. Are we saying that because the Chief Justice is affected, she cannot affect her constitutional mandate? Who's taking it away from her? The same thing about the Supreme Court. If such a petition should come, should the Supreme Court then say, it's okay, we are going to Manyata because we cannot find a petition against ourselves? What about what Article 168 says? So these are important questions of the serious legal and constitutional questions we ask. They are not flippant. And they only make their democracy better. I have no problem going home if somebody proves I am Bure Kabisa. Manyata, like I said the other day, we have a tarmac now to Samburu, so it's okay. But you cannot remove a judge willy-nilly. Removal of the apex court should be on a very serious ground. It cannot be games on social media. It cannot be. Removal of the apex court in the country is decimating a whole arm of government. You cannot have a democracy when a whole arm of government is collapsed. That is where we are if we continue with this absurdity. So, Shundu, that really is the issue we are addressing. Let's see how they pan out. But yes, you've raised a fundamentally important question. Thank you. So what do we call me to come? Now I'm here. Are you happy? She's very happy. So thank you, Christy, again. So Christy's question and Marion's are tied up. So one of the, because of the way the court and the judiciary are wired generally, we have this old English saying, judges speak through their judgments. But suppose nobody reads those judgments. How will they know what you said? So this series of lectures is a good way for us also to speak, especially to you young scholars, about our decisions. And Christy has pointed out to two judgments that I myself consider flagship of the court. The first is the Muratoto judgment. The Muratoto judgment was a judgment around the mandatory nature of the death penalty. When I was in Embu here in Meru, I had a very interesting way of delivering death sentences. So I have cufflinks which one is written guilty, one is written not guilty. The day I'm going to sentence a person to death, my right hand cufflink will read guilty. Because it's a very serious job you're doing. And the old saying about sentencing somebody to death was, I hereby sentence you to death. You shall hang by the neck until you are certified dead. May God have mercy on your poor soul. And then the judge was supposed to break the pen which he used to do the death sentence. So that pen does not write again. That's how serious the death sentence was. And the reason was, judges then used the following words. I have no say in the matter. The law says once I find you guilty of murder, I must sentence you to death. Then we realized that our constitution and the values in the Bill of Rights did not actually make the death sentence mandatory. Because some of the cases I did in Meru were cases that ultimately I never sentenced the person to death. I reduced the sentence from the charge from murder to manslaughter and give the fellow 10 years or 5 years. For example, the guy who in Meru who he was sleeping under his mirror tree, and one young boy kept coming to steal the mirror. So he beat him up at 9. The boy ran to his house. This Muzee followed him at midnight, beat him up again. Then at 3, he went back, beat him up again. Then he went at 6 on his way home, beat him, the guy died. When he came to my court, when I asked him, because I never used to just write mechanically the plea, I'll put my pen down and say, niambie nini ilifanyika? The guy says, Judge, nilimchapa saa 3 hajakufa, nikamchapa saa 6 hajakufa, nikamchapa saa 9 hajakufa, nikamchapa saa 12 akakufa. Now, you see, for him, he's saying, I didn't intend to kill him. I was punishing him because of continuously stealing my mirror. So we realize some of this, but if you ask him in Kimeru, did you kill that boy? He says, yes, I did. But when you ask him why, he says, I will just punish him for stealing my mirror. Now, if you look at the ministerial question and the actors' rules question, you can't apply it strictly in every case and sentence him to death. So that's why in Murotetu we said, judges and magistrates must have the discretion, depending on the circumstances of the case, to determine whether the death sentence is the only sentence they can give. And then we realize that circumstances will show that not every case deserves a death sentence. So please read Murotetu, because it's a case that will continue appearing for you, before you, in your exams at School of Law, maybe in the exams here, Murotetu will appear. The second case is a case called Mitubel and the William Musembi case. These two cases followed my judgment in the High Court called Satro Zayuma. In Satro Zayuma, I now did the principles to be applied when people are being evicted. In Kenya, at one point, eviction was the order of the day. Those bulldozers would go into slums, they would go into villages, they would go into the Mara Triangle. In Satro Zayuma, people are being evicted from the Mudurwa railway houses, where they have been since childhood. And so I gave the principles, which are now, I believe, Section 152 of the Land Act. They picked the principles in my judgment and translated them into the law. So Marion, those are the sort of things we do. If a judge writes a judgment that translates into law, what better feeling for a judge that your judgment has affected society in a positive way. So in the Mitubel case also, we now gave what we call structural interdicts. Please read on structural interdicts. They'll continue becoming useful in your life. In William Musembi, again, the Moi Educational Center in Nairobi, West, they went and evicted people in a slum completely, at night, it was raining. We gave them damages because we said, even if you're evicting because they have no rights to the land, there is a humane way and a Bill of Rights for evicting people. So these are the sort of cases we have done which have had an impact on society. The same with the Mitubel. Again, these were guys in a slum called Uhuru Cotton near Wilson Airport. They were evicted at night. Again, we gave them damages. So these cases have meaning, and please read about them. The cases we are now dealing with are Sexual Offences Act cases. Now, when my colleague Joaquin Dongo was in Parliament, and she led in the drafting of the Sexual Offences Act 2003, she drafted the act in a manner that we have minimum mandatory sentences. So even if a magistrate has discretion, you can't be given a sentence of less than 15 years, for example, or less than 10 years. And some sentences, like if you defile a 3-year-old girl, that is life. What has happened? Following Murotetu, magistrates and judges, including the Court of Appeal, have said that mandatory minimum sentences are unconstitutional. So we are now having, the other day we saw a case where this character defiled a 6-year-old girl. The magistrate sentenced him to death, to life in prison. The High Court upheld the sentence. The Court of Appeal reduced the sentence to 40 years in one case, in a second case to 30 years, saying the mitigation he gave should have been taken into account, and therefore in all sexual offences matters, life should translate to 40 years. We are having 2 judgments in the Supreme Court now where we are addressing that question, because there is an issue whether courts can determine that if the legislature has said the sentence shall mandatorily be life, can the courts reduce a minimum mandatory sentence into 40 years or 30 years? And is that a good precedent following Muratetu, or have they misunderstood Muratetu? So wait for those two judgments. When you deliver, I'll probably, Chris, you can ask me to circulate to you, and you can circulate to the others. So those are some of the cases we have handled, which have an impact on society. They are not academic at all. The East African Court of Justice. Please read the advisory opinion by the Attorney General we delivered last year. It is called the advisory opinion by the Attorney General on the mandate of the East African Court of Justice. The Attorney General, then J.B. Muturi, came to the Supreme Court and asked the Supreme Court, what is the relationship between any apex court in East Africa and the East African Court of Justice? Can the East African Court of Justice review decisions of the apex courts in East Africa? Can they review the merits of a decision made by the Supreme Court of Kenya? And this follows the Karua case, and Karua has a second case now on the 2022 election petition for the presidency. Sonko has his case. So we have determined the cases finally at the Supreme Court. They have gone to the East African Court of Justice. My view remains this, and I speak as a judge who sat in that court for 7 years. The East African Court of Justice was never meant to review the merits of a decision of any partner state court, more so the apex court. The link includes what is called the preliminary ruling mandate. If a judge of the High Court in Embu has a case which involves interpretation of the treaty for East Africa, you send that question to the court in Arusha. They determine that question around the treaty. They bring it back to you, and it's binding on you to use in your judgment. That is how the courts, in municipal courts and the regional court, are wired. It was not meant to be. However, under Article 6D and 7.2 of the East African Community Treaty, the court can interrogate violations of human rights by organs of partner states. But in doing so, I don't believe myself that it is their business to interrogate whether a court has violated the treaty. Because by doing so, you must interrogate the merits of that court's decision. And if you look at the Martha Karua case, they actually interrogated the merits of our decision. They looked at every issue we had raised, and they interrogated and then found it differently. And I'm saying that's not how the East African Court was meant to be a court to interpret the treaty. The treaty is an economic treaty. It is not a treaty of any other kind. It is about business between the states. So when the court now turns itself into a Supreme Court, it's getting out. There was an East African Court of Appeal. And if you look at the ICA reports, that was how the court was. All the appeals from East Africa would be had by one court. That is not the court we conceptualized when the treaty was enacted. So we are still having that debate, but if you look at the advisory opinion we wrote last year, it clarified the role of the court vis-a-vis the apex courts. I think I've answered Maroro. Kevin, so 2 things that I would encourage the school to please take seriously. One, the issue of mentorship. I've realized that your generation, unlike mine, is struggling with many issues. Many issues career-wise, many issues health-wise, especially mental illness. Just preparing yourself for the future. The world is harsher in your time than mine. You need mentors. So if you don't have already, I believe you have, put together a very strong and vast mentorship program. I have over the last 10 years, put together a team of almost now 50 young lawyers, mostly from Strathmore, because I'm closer to Strathmore. And I meet them thrice a year, and I bring speakers. You know, when they want to speak about careers, money, how to make money, how to manage your mental health, how to progress academically, have brought speakers to them. And I found that it has helped them. Even those who have their law firms still attend those meetings. So please put together a good mentorship. Number two, and tied to that, is the alumni network. I'm the chairman of my university class. We call ourselves MV90. We left the University of Nairobi in 1990. I don't know whether you have a video of a lady called Mary Wangari, former director at Equity Bank, speaking about how our class works. So when we reconnected in 2017, we put together a very robust welfare network. We also put together a book club. We have a farmers club. We have an investment LLP. And the girls have their own group. All these groups are helping us. For example, in the welfare group, I believe we're the only class alumni which we don't fundraise if we are bereaved. What happens is we have money in our account, we contribute 20,000 shillings a year, and if you lose a parent, as soon as you give me the information, we put 250,000 into account within 48 hours. If you lose a wife or a class, or if you are married from the same class, like I know some of you here may marry each other, which is a good thing, we pay you 400,000 to bury your spouse or your husband or your wife. So we don't struggle with the Lenaola 50, Marion 100, so and so 100. No, we don't do that. So we don't fundraise at all. We lost a classmate who had been unlucky, got him to drink. By the time he died, he had no house in the village. We built a house for him in 2 weeks at 2 million, I believe. Our investment wing, chaired by Koki Muli, the Dean of the Faculty of Law at Southeastern University, Seku, she's our chair for the investment wing. I think now we have 80 million in treasury bonds. And every 6 months, our accounts money just drops like this. So these alumni networks are very strong. The other day, Christy went to a school called Alliance Girls High School. I went to the Alliance High School, thank you. And we also have a very strong network of old boys. 2 weeks ago, we took the Chief Justice to speak to the boys a month ago. And 2 weeks ago, we had a fundraiser for the new school hall and new school chapel. We have raised now about 40 million, because the government is giving 60 million. So alumni networks do work hard, and I go for mentorship lectures at the school as often as I can. The University of Nairobi has a very strong alumni network chaired by Isaack of NCBA Bank. I encourage you, like Kevin has said, please set it up now. Don't wait for the alumni groups to grow. Even the 2 groups that have gone out, and those who are here can begin that conversation, and you can involve me if you think I can be of help in setting it up. Thank you very much. Well, thank you very much. I believe myself that the work of the judiciary in every single case involving the legislature and the executive, for example, is to ensure that you play your role as the interpreter and applier of the Constitution. The Supreme Court mandate is to apply and interpret the Constitution. And if they go wrong, tell them so. If you recall, there was a big fight between the Senate and the National Assembly. We resolved that dispute. They came back. Right now we have a judgment pending delivery where 23 cases passed by, 23 statutes passed by the National Assembly have received disapproval from Senate. And Senate is saying there are some cases that involve devolution, which the Senate must have a hand in. Those 23 cases were passed by the National Assembly. They are operating, but the Senate says strike them down until they come through the Senate. We are going to resolve that issue in a couple of days. You also know, for example, that there is always a fight between the Senate and the National Assembly around revenue allocation. They never seem to agree on what goes to devolved units and what doesn't. Again, we have resolved that question in a case called the revenue allocation case by the Supreme Court. Please read it. We have also, over time, struck down laws that are found to be unconstitutional. I've just spoken about the CDF case. which we said was unconstitutional. There are many others we have struck down at the High Court level. Many decisions of the President, of ministers, are being struck down because they don't follow procedure, including on public participation. So that is our role. Whether we have failed or we have succeeded is for you, the critics, to tell us. But I, speaking for myself, I think we've had a very robust judiciary since 2010. I sat and headed the Human Rights and Constitutional Division for 6 years. Post 2010, I was the first guy soon after the 2010 Constitution. And so I know the judgments I wrote at that time are still being held in high esteem because they made a difference in securing gains for the Constitution. But also remember, 2010, everybody was thrown to the deep end of the Constitution. A lot of people didn't even know. For example, people thought senators were more powerful than governors. After 2017, they realized pesa iko wapi? Iko county. So all the governors, senators were running to run for governor. So people didn't understand the Constitution. It was our job as a judiciary to point everybody to the right place. So I think myself, on a fairly balanced analysis, the judiciary has done a good job. AI in judgment writing. So I lead in the ICT issues in the judiciary. And I've just put together a team to create guidelines on the use of AI in the judiciary. And I'll give you two stories that may worry you and worry me. A judge in Brazil, I was in Brazil 2 years ago, and we saw how their uptake in technology is higher than ours. But in Africa, we are one of the best in terms of technology use. So this judge called Rodriguez gives, by the way, I must thank my law clerk, Samuel Nyambani, who's here, because we do a lot of work together, including put together this speech. So he tells a guy like Nyambani, put together for me a draft judgment. Nyambani goes to ChatGPT, puts together a draft, and sends it to the judge. The judge doesn't look at it, he delivers a judgment. When they now critique the judgment, 6 of the authorities which were quoted were fake. So the judge is going through proceedings in discipline. A judge in Colombia did the same thing, but his was even worse because ChatGPT completely misled him even on the facts of the case. So he didn't take time to look at the facts of his case and the one created by ChatGPT. So anybody reading it will say, but this is not the case which you had. So he has fake authorities, even have fake facts. So it's worrisome. Then in the case of a guy called Cohen, Cohen was Trump's lawyer. He was jailed the other day during Trump's issues before he became president again. The law firm acting for him gave a judge fake authorities. And the judge discovered. So he fined them $5,000 because of that. So it is here with us. In the judiciary of Kenya, we know that people are using ChatGPT, DeepSeek, and others to do research. But we are saying to our judges and magistrates, be afraid. The other day during a conference of the Supreme Court last year, I was chairing a panel on AI. And as I was introducing the panel, I went to an app called Nova on my phone. And I asked Nova, who is Justice William Ouko, who was seated right in front of me? William Ouko is the Chief Justice of Kenya. He has been Chief Justice since 2016. So I told my colleagues, it is very easy for this thing to lie to you. Although now what they do at the bottom, they say, this information may not be accurate. Verify it from whatever. So, yes, we are dealing with it. But the way we are using the judiciary today is in a very limited manner. We have a pilot phase of the National Transcription Center. One of the difficulties we've had over time is that proceedings from one court to the appellate court are being held back because they're all being typed manually. Now we have, because of the recording of proceedings, we have an AI tool that quickly transcribes the recorded material into print, and then all that our transcribers do is proofread by listening in from what the AI tool has really done. And we intend to do that for the entire judiciary so that we reduce the backlog of cases because of delays. But the bigger arrangement is that we are putting together guidelines. I spoke to the Law Society of Kenya ICT Committee, so they can also start putting together guidelines for themselves to put together guidelines for lawyers even as we put together guidelines for the judges and magistrates. So it's a new future, it's a new world. We can't escape from it, but we must be careful. And then lastly, lesson for the youth. I frankly cannot recall any judgment I wrote. Okay, maybe one. So some years back, I received in the High Court at Milimani 777 petitions seeking nullification of the recruitment of policemen. What had happened was that particular recruitment was so marred by corruption that the whole country was up in arms. Families were selling land, they were selling cows, they were selling sheep, they were selling houses to bribe the people who are doing the police recruitment. So by the time we received across the country petitions seeking nullification, the Chief Justice said, bring all those petitions to Lenaola. I consolidated them in Nairobi, had the petition, and nullified the entire recruitment for the country. The president was exceedingly mad with me, President Uhuru Kenyatta. So I woke up to a headline on Sunday morning. Uhuru Kenyatta said, all the recruits who are taken should report in Kiganjo. So some of them went to Kiganjo, but I think he changed his mind. And the recruitment was done, redone, and I think the correct process was used. Why was that useful for the youth? Because you guys know that today, a lot of you tell me, because people ask me for help to get job. They say, unajua judge, upwezi pata kazi kama ujui mtu, ama utoe kitu. Your generation is suffering both because of your own conduct and the conduct of those on our side. That you cannot get a job without bribing somebody. That merit is being subordinated to bribery. So I tell people, I do not bribe and I don't get bribed. So if you want a job from somewhere, don't go and bribe. Go on your merit. And that's my message to you also. Integrity can take us far. If each one of us starts being a person of integrity and we spread that message across the country, this corruption will die. But if all of us join the bandwagon, you're driving your father's car, your policeman stops you, you have done nothing wrong. But the first thing you do, you give him 100 shillings. Why? What have you done? And that's the culture we impugn in you, the youth especially. So I think myself that the fact that I was able to stand to corruption in that judgment, I was able to stand to the system and tell them, no, we must do things right. I think I took a bullet for the young people of that time. Let me close by saying this. Dr. Ngige, you raised something about critiquing judgments of the Supreme Court. When I spoke at Strathmore, a lecture like this one, I also said it is not enough, for example, for some of our friends to write on one line of Twitter or 3 lines of Facebook that judgment is chenze kabisa. We as scholars, we should write critiques that are well reasoned. I read the Platform magazine, published by Bitobi Manyara religiously, and he uses a lot of students to write articles in that magazine. And I get a lot of good commentaries, some critical of the Supreme Court, but I'm happy to read something reasoned and actually take them very seriously. I go back to a judgment. If a student has pointed out an error in the judgment, I always go back to the judgment to say, maybe yes, maybe this student is right. It's a lesson to us. We are not beyond mistakes. It was just Chief Justice Roberts who says, we are final not because we're infallible. We are only infallible because we are final. The fact that we are final does not make us God, saints, angels. But if you point out these things through critiques, reasoned critiques. One time I spoke about somebody saying, the Supreme Court contradicts itself. And then I said, what is so difficult about putting together a paper, even a 3-pager, showing the contradictions? And one young guy actually took my point and wrote a 3-pager. I didn't agree with 3/4 of what he said, but at least he put his mind to showing what he thought were contradictions. That's how we should be. And scholarship does not mean that we also follow the bandwagon of the social media types. So we only are keyboard warriors on social media, not keyboard warriors in putting together our thoughts into scholarly and academic papers or books. I'm on my 3rd book, and I'm still a judge, and I'm happy to write what I can when I have the free time. Why can't you write books? Why can't you write critiques? You can, because you are very intelligent people. I've enjoyed your questions, and I hope to come back again soon to speak again to you on a different topic, especially the topic of, you had asked me to speak about abductions. When the heat is off, I'll come back. Thank you. Thank you very much. Applications. This is the Supreme Court Yearbook 2023. It has a few of the events that we have done that year, and it's a good read for your library. Thank you. 12 years of the court, we put together a publication which is reflections, 12 years of defending the Constitution. Some of the questions you have may be answered by this. My personal experiences when I came to the court, they're in this document.
It captures our high moments in the year. So I thought you will be appearing in 2026.
In every term, we have a judge giving a live lecture like this one. So that is where I'm looking for. And when I told you are going to the promised land, you can see the journey has started. I don't want to say much. I want to stop here because, again, we have really to be conscious of time. Is just another commitment at Nairobi. Thank you so much. And